The governing rule in Islamic law is that in order to enter into a contract of marriage and in order to pronounce divorce, a person must have legal capacity, which stated simply means that he should be major and sane. The question arises whether such a person loses his legal capacity when he is joking or is being coerced or when he is intoxicated. The response may be that he has not lost his legal capacity, but his ability to issue voluntary and intentional statements may be affected. Islamic law, however, maintains that for purposes of marriage, divorce, and emancipation of a slave, the making of voluntary and intentional statements is not a condition for the validity of such contracts or transaction. Thus, offer or acceptance by a sane person who possesses the legal capacity to enter into a marriage contract does not prevent the conclusion of a valid marriage contract even when the statement is made under coercion, by way of jest, or by mistake. The basis for this is a tradition from the Prophet, peace be upon him. 3 things done seriously are taken seriously, and if done in jest, are taken seriously: divorce, emancipation of a slave, and marriage. Marriage may be easy to undo, but divorce is a different matter. The Hidayah, therefore, mentions the law for divorce under coercion. It says, the divorce of the person coerced takes effect, that is, it becomes legal. The author goes on to mention that Shaafi'i does not agree with this rule. He argues that coercion cannot exist side by side with volition, and it is through this that acts are legally acknowledged. The Hanafis respond to this by saying that the person coerced has intended the occurrence of divorce with respect to his legally married wife while he was in possession of his legal capacity. His legal capacity and volition are attributes that are not lost due to his situation. He was well aware of the 2 evils, and he has chosen the least of these. The choices he makes are an indication of his intention and volition. He is not happy with the legal effects of his act, but this does not alter his legal situation. The position of the person acting in jest is the same. With respect to intoxication, the Hidayah says, the divorce pronounced by an intoxicated person takes effect. The Shafi'is do not agree and maintain that such a divorce does not take effect. The reason, in their view, is that intention is considered valid due to the existence of the rational faculty, and an intoxicated person has lost this faculty. It is like the loss of the reasoning faculty due to the use of henbane or some medication. The Hanafis maintain that he has lost his reasoning faculty due to a cause that is an offense. The legal effects of his words have, therefore, been retained as a deterrence for him. This discussion takes us to the question as to when is the intention of the person pronouncing divorce relevant. In response, the jurists say that when the words used to pronounce divorce are explicit and convey the meaning of divorce in clear terms, that is, the words are Sareeh, it is the meaning of the terms used that is relevant and the intention of the husband is not taken into account. If divorce is pronounced in indirect terms, through allusion, and by using figurative meanings, the validity of the pronouncement may in certain cases depend upon the ascertainment of the intention of the husband pronouncing divorce. The Sareeh words that convey a clear meaning of divorce are the word talaq and its direct derivatives. It is like saying, you are divorced, I have divorced you, and such words that convey the meaning clearly to one who is listening. The objective meaning is relevant and intention is not to be referred to when such meanings are clear. If a person uses such words and then denies that he did not intend divorce, his denial is of no relevance. The words used by way of Kinaayah or allusion can lead to a large number of statements that can in certain cases be construed to mean divorce, but can mean something else too. These are statements like, you are buy-in or separated, you are set free finally, your affair is in your hands, you choose, I am not standing in your way, I have granted you khula. There is no nikah between you and me. You are a free woman. Go join your relatives. I have no means of approaching you. Vacate your womb, and statements of this nature. These statements have double meanings. They are to be related to the context and then interpreted. The statements are divided into 3 types. First are statements like, your affair is in your hands, you choose, vacate your womb, and you are all alone. These are usually not used in anger or by way of abuse, and if the context is that of divorce, they become even clearer. Intention may be ignored in such cases if the context indicates that divorce was intended, in which case the words are construed as direct expressions of divorce. Statements like, "Your affair is in your hands and you choose," give rise to the delegation of the right of divorce to the wife. The second type includes statements that may amount to hurling of abuses, even though they may be construed to mean divorce. These are statements like, "You are haram," "You are ba'in," or terms that can be used as abuses in anger or otherwise. In such cases, intention is taken into account along with the context in which the statements were made. In other words, the construction placed upon the statement may go against the claim that divorce was not intended. The third type includes all other statements. It is the intention of the husband that will be taken into account, and a claim made by the husband that he did not intend divorce will be deemed credible in a court of law. Divorce in writing removes most of these problems, but the cases may arise where the spouses wish to observe the requirements of the traditional Islamic law rather than the law of the state.